Well, Huntington and Cabell County's 8-year legal fight with pain pill distributors to get them to pay for the impact the opioid crisis produced had a critical round today before the West Virginia State Supreme Court.
And reporter Bob Aaron says a negative ruling from the Supreme Court ends their fight to hold opioid distributors responsible for dumping 81 million pills in the county. But even a state Supreme Court win, it's not going to guarantee that the city and the county will prevail in the case.
Huntington and Cabell County, ground zero or close to it in the opioid crisis, were among the first to go after drug distributors. They sued AmerisourceBergen, Cardinal Health, and McKesson in federal court, arguing the distributors created a public nuisance that produced a health crisis. But in 2022, federal Judge David Faber ruled in favor of the pain pill distributors, saying the state's common law of public nuisance did not cover the sale and distribution of the dangerous prescription drugs. Huntington took its opioid case against the distributors to the federal court system, and its appeal is at a federal appeals court. But in a somewhat unusual situation, that appeals court has a question for the West Virginia State Supreme Court. It asks, under West Virginia's common law, can conditions caused by the distribution of a controlled substance constitute a public nuisance? And if so, what are the elements of such a public nuisance claim? A ruling for the distributors would kill Huntington's appeal. If the city prevails, it would send the case back into the federal system.
And what they did was persuaded Judge Faber to adopt erroneous legal standards of what the elements of a public nuisance claim are under West Virginia law. And on the basis of that, the court made the wrong fact findings. It wasn't the doctor's fault. The doctors couldn't have prescribed opioids if they hadn't shipped 81 million dosage units into Huntington and Cabell County.
If I didn't know better, Your Honors, I would think that we were here on a direct appeal and not a certified question. Because the bulk of the argument that the opposing counsel just made goes to issues that are not before this court today.
Ruby argued the federal judge was correct and this court did not have to answer the question. He warned a ruling favorable to Huntington would turn product liability cases into public nuisance lawsuits and threaten West Virginia's energy industry.
The cause of action that the petitioners are asking you to embrace have been used to sue energy companies in cases about global warming. And that's particularly important here in West Virginia, where we depend on the energy industry.
After watching the arguments, officials made it clear Huntington is still dealing with the issues that sent it to court in 2017.
Cabell County Commission standing here with the mayor will tell you that we continue to have an opioid epidemic and that we continue to try to abate it every day, that our men and women on the front lines that are first responders are feeling the impact, and certainly the residents of both Huntington and Cabell are feeling it.
Now the case is submitted to the state Supreme Court. In Charleston, Bob Aaron, Eyewitness News.
Well, 2 of the justices, former legislators, were disqualified and replaced by circuit judges Tara Salango from Kanawha County and Andrew Dimlich from Raleigh County. No word yet on when they will make their ruling.
Thanks so much for watching. Here's another video from Eyewitness News. Just click right here to subscribe to our channel and make sure you hit that bell notification to get the very latest.